See, I love myself in the chat. So today we'll be looking at what to do if you're sued by a creditor, right? I know normally I put together the PowerPoint presentations, but I stopped and slowed it down because rewatching those videos really upset me because I feel like I wasn't hitting the points I wanted to hit. Number one. Number two, I hate how I sound when I read from PowerPoint presentations. So I'm going to try to teach the Umar way this time without the presentation. So y'all be real and criticize me as we go like y'all normally do. I don't mind it. It helps to keep me going. So we are going to get started. Everybody else should be able to get in when they get in, but I want to be fair to the people that are here. So a few things we're going to cover, right? This is very important because creditors have been ramping up their lawsuits around this time. One of the main reasons I believe is because people are so preoccupied with just life in itself that people don't have the time to want to go educate themselves on what to do in these particular instances. So I want y'all to take notes, right? Since I'm not going from a PowerPoint presentation, y'all do have the recording, obviously, but I still want y'all to take the best notes that you can, because I'm going to test some people at the end of this to see if you were paying attention. So you might want to take notes. The first thing you want to do if a creditor sues you, this is our American Express, this is Discover, this is Capital One, right? Is you want to read it. A lot of people don't read it. They just immediately panic. Read it, right? The whole thing, and it's normally not that long because they never really have that much to say, and I'm gonna explain why in a minute, right? But number one, you want to read it, and the first thing I do is I look at the case number, and I look at wherever they sued me, or whatever district they sued me in, right? And then I take that case number and search it in that district website to make sure that it's an actual lawsuit. Because you know, it's not hard for somebody to pull up debts that people owe and make something up, right? And say that this was assigned to them, which comes to our second point. After I read it, there's something that I'm going to look for once I find out it's a real lawsuit. The first thing I'm going to look for is, do they use the word debt? Did y'all write that down? What did I just tell you to write down? This is very important, and I'm going to explain this to the T in a minute, and I'm going to show y'all something on my screen. Bingo. Thank you, Cecilia. Do they use the word debt? Now, I have a current person who's in my one-on-one mentorship program. He gets sued by this company for $5,000, right? And he gets on the call and he says, yeah, you know, they're suing me for a debt. I said, okay, send me the paperwork. He sends the paperwork. I read through it. I said, where do they say the word debt? Right? He says, I mean, I owed something to this company. I said, where do they use the word debt? He couldn't see the word debt. They used the word account. I said, okay, so now what law do they state? He said, none. I said, okay, and if they did set a law, what law would they possibly state? He said, maybe the FDCPA. I said, okay, go to the FDCPA and define the word account for me. It doesn't exist. So they can't sue you for something, number one, you can't understand, but number two, they can't sue you for an account because you don't owe money on an account. They purposely don't use the word debt, and I'm gonna tell you why. It's nothing spooky. It's something that I can show you proof of in a minute, right? They don't sue you for a debt because in order to make money and protect themselves when you initiate a credit transaction with them, these publicly traded companies like American Express, like Capital One, do what's called a process called securitization. They take the debt that you created, right, and they transfer it to a secured trust, right? Now, the thing is, when they transfer to that trust, they never transfer it back to Capital One. And the trust never assigns the debt to anybody. It just puts it in a pool of credit card receivables, and then they trade on it. So pretty much the best way to explain that in layman's terms is like this. If I go into a toy store, if I go into a tool store and I finance this screwdriver, can everybody see this? I finance this screwdriver. Whether I can afford it or not, I finance it. Right? Everybody can see my screen? I finance this screwdriver. And then this jar comes, this jar is an investor. Right? I'm going to sell the fact that you promised to pay me for this screwdriver, or I'm going to transfer it to a trust so this investor can invest in the fact that you promised to pay. But I never make you aware of that. which is why if you look at any of your agreements or contracts, they rarely use the word debt. They just say account. When they send you letters every month, they don't send you the word debt. They say your account is past due. Did they ever say your debt is past due? Jump in the comments and tell me if you've seen that before we proceed. Why don't they say debt? I don't. The debt exists, but it's no longer, they no longer have it. So then this goes deeper. We're gonna get back to the lawsuit. Am I doing good without the PowerPoint? Are y'all liking this so far? Dropping I love myself in the chat if we are. So now you'll fall on hard times and that you'll charge off. There is no debt, so I say the account charges off, right? Then they go and sell the account, not the debt, to a third-party debt collector. We should call them account collectors, right? They all see all the fraud that took place, so it was transferred to a secure trust. Then they sold the agreement and the account to a third-party debt collector, so there is no actual chain of assignment because there is no debt, right? So now I'm not gonna go too deep into the third-party debt collector part. I'm gonna go back to being sued by a creditor. So now when I'm sued by a creditor, this is Capital One American Express. Before I proceed, I'm gonna show y'all proof. This is all you have to do. Let's just say American Express, right? Let me share my screen with y'all. Can y'all see my screen? What do y'all see? Do y'all see American Express? Okay, perfect. Can y'all hear my voice? All right, so a 10K form, does anybody know what that is? If you trade stocks, you better know what that is. You should not be trading. This is a form that has to be filed with the SEC, Security Exchange Commission, every quarter, right? This is for all publicly traded companies. So I'm going to scroll down and I'm going to press Form 10K. See, this is a government website. I can't make this up, right? Now they had to report everything that took place. All right. They even have a file number, so you could actually reference this in one of your letters. So now what I'm going to do is I'm just going to search. Hold on, on my computer. Why is it doing that? Hold on, let's see. Normally I can search it. Okay, let's go back to Google. So this is just what I searched. I'm gonna scroll down, and you can do this for any publicly traded company that you have a credit card with. So you can put Discover, American Express, anybody right there. We'll press that. And this is their annual report. All right. Now in here, they talk about securitization. So hold on, I know what I have to do. I think I have to stop sharing my screen, search it, and then bring y'all back. 1 second. Come on, computer, don't start this. There we go. All right, got it. So I'm gonna search securitization, and it says, we meet our funding needs through various sources, including direct and third-party source deposits and debt instruments, such as senior unsecured notes, asset securitization, and secure borrowing facilities. The cost of funding card member receivables, remember I use the word receivables, and loans is a major expense of our card operations. Centurion American Express Bank financed their charge card receivables and credit card loans in part through the issuance of medium-term notes and by accepting consumer deposits in the United States. TRS Centurion Bank and American Express Bank also fund receivables and loans through asset securitization programs. Did everybody catch that? Did everybody catch that? Do I need to read that again? They're making it clear, right, that they securitize. Nothing spooky. It's not like Anybody can look this up, right? So when you go get a credit card and they take the debt and they securitize, they transfer it to a secure trust. Now, how does this apply to you when they sue you? Because like I said, beginning, number one, they never use the word debt. So now we're going to find out what trust American Express transfers their debt to. So this is all we're going to do. I'm going to share my screen with y'all. They still own the account, but they no longer own the debt. That's why they only sell the account. They don't sell the debt. And so like I was saying about the person in the one-on-one program, the biggest issue he had was he kept saying he owed a debt when they never even said he owed a debt. They just said he owed on an account. Y'all see what I'm saying? You can't define account. Show me the law that defines that. All right, so I'm on ChatGPT. I'm going to tell him to, or she, whatever it is, find trust American Express uses to securitize. I'm sorry, y'all. Securitize their debts. All right. So they have two trusts, right? Now, what am I about to do with this information? Does anybody know? I just want y'all to guess. No, not an affidavit. Nope. I want y'all to keep guessing. Keep guessing. I'm gonna show y'all in like 3 minutes. Keep guessing. But what I'm gonna do is I'm gonna search this trust and get the EIN number. That's what I'm gonna do. Now, if y'all chat doesn't do this yet, don't trip again. Remember, I've been training mine for a while. A lot of people think this thing knows everything. It doesn't know everything. It has to be taught certain stuff. Once you teach it, it does do pretty good. Where is that link I'm looking for? Oh, yeah, we're gonna find this one link. I just used it. You know, let's search them right here. Let's try that. All right, so this right here is showing you all of the things they securitize, right? But hold on, let's go back because I like the way it came out. So here you can pull up their 8K and 10K reports. Let's see, the latest one is December 16, 2024. And y'all check this out. Here's the IRS identification number. They even put their telephone number. What am I gonna do with this information? They even tell you who the president is. All this information is public. This is not a secret. Right? So now I know that the date that now I know that the date that that you did business with them, right? That they did business with them, that's the date that they transferred this into that pool and transferred it to the trust, right? So now what I'm gonna do in my response to this lawsuit is first, I'm gonna go back into ChatGPT and I'm gonna do this. Pay attention. See that? Bingo. We had the EIN number too, so I'm gonna go right back and get that. They're really gonna wonder how in the hell you knew that. Right? Let him write that out. We'll come right back to it. All right. So somebody just said, can you add case law? Now, y'all have to double check your Chat GPT because if it's not trained, he may add case laws going further. But I've been training mine for a while, for about almost 6 months now. Look at that right there. And look at that right there. He added the case law. Bingo. Bingo. Now, what do you do with this document? First, I'm gonna show you somebody I probably didn't know. ChatGPT can do this. Now, what am I gonna do that? Well, it takes him about 2 minutes to do that, so let him finish that. What am I gonna do with this document next? So Julia said, can you show what you originally typed? First, I typed this, Julia. And welcome, Julia. If I'm not mistaken, you're new. Now, Maurice, you one of my one-on-one people. You know you ain't supposed to be putting that, bro. Yeah, I put my bro Maurice on the spot. All my one-on-one people, I put them on the spot. Maurice is my boy, so I just put him on the spot. Everybody comment Maurice no in the comments. Just to put him on the spot. That's one of my one-on-one people. He know better. All right. Now, what I tell people to do is, yes, you have to mail it, especially if it's in the state court, you to the mail it to their attorney with a certificate of service. You got to ChatGPT draft that. But then to the court, I tell people to go drop it off in person and let the clerk stamp it in person. Especially if you're being sued where you live, just go drop it off in person. But you can mail it in. I'm not saying you can't mail it. I'm just saying that's what I normally tell people to do. So Julia want to know what I first worked. First, Julia, what we did was we made ChatGPT find their secure trust. He showed two of them, right? Then after he found them for us, we made him draft this, a motion to dismiss for lack of standing because they no longer own the debt. And they have to actually prove that they own the debt, right, to be able to collect for it. So somebody wanted me to add case law, so we added case law. Remember, my ChatGPT is trained, y'all. So don't be tripping if yours messes up. You got to give it a chance to learn, right? So it said a party must demonstrate ownership and the legal right to enforce a debt to have standing, which they do not have because they transferred it and never transferred back. All right, so now the next question I ask y'all, right, is what we're going to do next, right? All right, Julia, hold that. Julia, hold that for the Q&A and I'll show you what you need to do. All right. Fred, what up, bro? Um, the first thing you're gonna do is okay. So I have an instance for a family member where they moved out of the state where they were being sued, like they moved like the same week they were being sued. So in that case, I would tell them to mail it into the court, right? But let's actually talk about that. If you have to, this is why I have to read your agreements to the T. So let's pull up an agreement, actually. Let's do that. American Express agreement. Let's see, what's the most common one? Let me download this. Is this video going to be uploaded to the? Yes. Oh, I'm trying to write down on that. Okay, there we go. Got one. Hold on, let me share my screen with y'all. This is an American Express agreement. Let's see. They possibly use the word debt one time in here. Let's go down to default. Normally you'll see the word this is just the agreement. This isn't the lawsuit. Remember the lawsuit, they don't use that word. But and if you have a lawsuit, check it now to prove me wrong. Um, let's go down to default. So right here they say you agree to pay all reasonable costs, including attorney fees that we incur to collect amounts you owe. They still don't say debt. They say account. All you're gonna do is see the word agreement and account. Now I'm pretty sure they're gonna say it under there we go. Oh, that's debits. I'm sorry. Come on, where is it? And if this was a debt, don't you think I should have seen the word debt by now? I'm almost certain they use it at least once in the agreement. They always do. It's normally under the part about collections. Let's see. You'll see under this agreement. That says debits. I thought it said debts for a second. There we go. All right, they use the word debts here. So let's read through this. We may consider your account. If it was a debt, they would have said we may consider your debt to be in default. Y'all notice they said account. Why are they using the word account? Let me just check the comment section. Now, the reason why they use the word account is because they're going to keep the account. They're going to attempt to collect any account from you, but the debt gets securitized right away. The debt gets securitized right away, right? Notice again, we're required to pay your account balance immediately. So all you truly see is account and agreement. But you can't find a law that they use that defines account. So this is why if you ever look at the FCRA, the Fair Credit Reporting Act, this is just a small thing I'm showing y'all. There's no definition of late payment. The late payment comes from the agreement. They talk about that in the agreement. This is why you have to read your agreements thoroughly. And this is why you use it against them when they try to sue you. It works in your favor. Let's see what Nicholas said. In my Synchrony Carbon agreement, debt cancellation comes up 5 times, but unrelated to the account itself or collection. See that? This is the game they play. They just play on words. That's all they do. All right, so let's go back to what we were talking about. Very true. Noor said in court, they never state the word of debt instead of account. That's two different things. How they gonna sue? And look, this isn't nothing spooky. Like this isn't nothing like I'm trying to prove how to use your social. No, this is public information like stock trading. The thing is, it's business. So we take it too personal. This is all just business. And now, because it's business, we're not going to take it personally. We're going to use it to our advantage. It's just that simple. So now, back to the point. Remember I said the first thing you want to do is read it. Second thing is what? Search for the word debt. Number 3 is you also want to read through the agreement and see what state governed the agreement. So let's actually look at this agreement. Let's drop it in ChatGPT to make it simple. And let's see what state governs this agreement. Because that if they're suing you on the agreement, they have to honor that. So they can't sue you in another state. Bingo. So all disputes should take place in Utah. Now, if they were suing you for a debt, that's different, but they're not. They're suing you for an account. Nicholas, now I got a screenshot that. I got a screenshot that. You going on the Instagram, brother. Oh, all right. So somebody else asked a question. I want to go through it because it's important. Who asked about Chase? Somebody just said they're facing Chase. So we can actually look through Chase together. If y'all have time, we'll look through Chase together. Julia, okay. So Julia has Chase, y'all. So now we're gonna go. Everybody got time? Y'all got time? Chris, no. So I don't I don't really like to all like if it's a third party debt collector and you don't want to counter sue, then you can motion for arbitration, right? But if it's the creditor, the first thing I'm going to do, I can't tell you what to do. The first thing I'm going to do is prove they're not suing me for a debt, and then I'm going to go back and counter sue them federally for that same thing. And then I'll even add on FCRA violations, right? All right, so Julia has Chase. Here's what we're going to do. What was the first step? Let's test everybody who was here earlier. What was the first step? Don't forget, y'all, January 4th, I'll be streaming live on Twitch for the first time. We may do a 24-hour credit class. All right, Soteria said read it. Perfect. Then what am I going to do after that? While y'all saying that, I'm going to show you what we're going to search. Um, Chase Issuance Trust. I'm going to take that. And then I'm going to search it, make sure there's an actual trust that exists. All right, it most definitely does right here. We'll pull that right up. We have the reports. Let's press it. And we got them. Right now, I'm going to have Bingo. And just that simple. Just that simple. And now what do we do it after that? I prefer if y'all take that up there in person, right? And then, yes, Julia, okay, so Julia said my motion got dismissed for not giving them a copy. So, you just do something like this with ChatGPT. You say, create a certificate of service. Then he's gonna create the certificate of service. And you take this, you sign it, and you send a copy of it, and then you send that to the opposing attorney, and you also send that to the court, so they have proof that you actually served them. All right, so now we're gonna get into the Q&A. You can either write it in the chat or you can raise your hand, and we'll go from there. And I would countersue in federal court and just use that as my settlement. So that would be my part of my settlement. I would tell them they have to dismiss that case or remove that judgment if it's a judgment. All right. And Anita Ingalls?
Yes. Hi, can you hear me?
Yep, I can hear you.
Okay. First of all, good evening and thank you for your time.
No, thank you.
Yes, I have a question about, so Discover sued me. I asked to arbitrate, in like a pretrial type thing. They said they had to consult with their client and, they never, when I came back for the next meeting, they never showed up. And so the case was kind of dropped. But she said, the judge said that they could do, I guess, like with prejudice, which meant that they could come back and sue me again. Is this something that I need to do concerning that?
Let me ask you this. How much are they suing you for?
Maybe about $3,000.
I would get a copy of, remember, this is just me. This is not legal advice. I would get a copy of it, of the lawsuit that they used against you. I would find an issue on my credit report. Now, they already violated the agreement y'all had because the agreement says y'all supposed to arbitrate all disputes. So I would
Yes.
sue for breach of agreement. Then I find some kind of Fair Credit Reporting Act violation, which could be a small, and I sue them for that as well in federal court and just completely get the debt wiped out.
Oh, okay,
That
awesome.
way it can never be reopened again.
Okay, so do I go in through the same court system or do I do a different one? It was small claims court.
You go federal. Don't go small claims. So you look up the federal court in your district.
Okay.
All right.
Yes, thank you.
No problem. All right. Fred said, Umar, we didn't get to finish talking from the other day. What happens if you got sued in the deck like they agreed to start paying? Is there a way? So I wouldn't motion to compel arbitration, Fred. I'm sorry, I meant to respond, bro. I was actually in the hospital the other day. I would sue that debt collector and just void the whole agreement from there because they actually don't have a chain of assignment or a chain of title. I'm certain of that because of what I just showed you. I filed a motion to vacate judgment. Judge granted it. Awesome. Rescheduled for February. Amazing. And is mediation standard because the lawyer mentioned that I also have an option. Mediation is different from arbitration. I actually prefer arbitration. Well, let me close this up. thoughts on the data breach method a lot of folks seem to be using as of recent. It's kind of old, bro. Like that data breach took place a long time ago. Am I against it? No. What are my thoughts on it? Was your question? If it works, I'm one of the people, bro. If it's working, use it. As long as you're not hurting nobody, use it. Yes, Marcus. Yes. Oh, I'm sorry. Hold on. Somebody got their hand up. Darius Butler, my bad.
Hello, how you doing, sir?
I'm well. How about yourself?
Pretty good. I actually joined your program, and I'm actually being sued by two debt collectors. Um, from the information I got, I did arbitrate with both of them, just by looking at some of your videos and using some of the training. But
Two
my
debt collectors.
it's actually it was sold with a charge off, and then the debt collector is coming at them.
Okay, gotcha. And who'd you arbitrate against?
I actually did it with both. It's actually with two credit unions. I know I seen you speak on Chase and American Express, or all the other banks. Have you ever arbitrated with like a credit union?
So credit unions normally, especially like Navy Federal, they don't have arbitration provisions.
Right. Neither one of them is Navy Federal, even though I do have them. But I'm not. It's not with. It's actually in my state, Michigan.
Can you write their name in the chat? Let's see if I can pull up their agreement.
Can you read that?
Drop their name in the chat while we're on here, and I'm gonna see if I can pull up their agreement.
Okay.
Because every agreement always has a dispute resolution section.
Right. I'll drop the name. It's actually two of them. It's Michigan First Credit Union.
Hold on. And it's for credit cards?
Yep. And when I actually looked up the agreement, it did say it had an arbitration clause in it.
Oh, okay, so they had one.
Yeah, it did. Actually, for both credit unions that I work with. And actually, when I did read it, it was saying that like they can hire a third party and they can do charge off, stuff like that. And when I read the agreement.
Well, no, I don't think that there's an arbitration clause in there, bro. Let's see. No, I don't think there's an arbitration clause in there. Now,
You
that's
sure
not.
that's not the business credit card? Because I when I looked at it, I was looking at the business credit card as well, and then it didn't say it in there. But then when I looked up the regular credit card, it was there.
Is it the Michigan First Rewards Visa credit card?
Yep, I think that's the one. Yep.
So I don't see a arbitration provision, but that's not something to stop you, bro. And the reason why I'm gonna say that is The reason I'm gonna say that is because, what I would do, now, what do they call? Credit unions have their own process of securitization and not normally public traded, but normally they securitize them through third parties and privately. So it's sort of the same process. I just can't pull up a 10K form on them like I could American Express.
Right.
So securitizing, that's one thing. But two, one of the big things you can do is catch them on data points. And it can be a small thing when it comes to data points. Something as small as them not putting the proper update date when they update your report after they claim it's verified. Right?
Right.
So you catch them on small data points. So, and I'm gonna give you a secret. Normally with these small credit unions, and I shouldn't even say small, because even like Navy Federal, they're almost always off with their data. I don't really know why. I'm gonna assume it's the computers, but their data is always off. So if I check people's report with Navy Federal charge-offs, I always find something off, whether it's an inaccurate payment history, inaccurate data first delinquency, there's always something off. So what I would do if I was you, I would look at the securitization part, but my main focus would be, my main focus will be putting all three of my reports side by side and cross-referencing each data point. And I promise you, you'll find something off.
Right. And then I also thought it was kind of suspicious when I got the summons in the mail. It just looked kind of bogus. Like they didn't even have the account number. They didn't have none of they just had the amount that was owed, but it was like blacked out. And they didn't even have like the account number on there. And I remember you saying on one of your
Hold on.
videos.
All right, pause right there, but listen to what you just said. Why don't they have the account number?
Because they don't have the information.
They sold that already. So
Right.
you get them on that. You file your motion based around that.
Right. I actually I did a defined statement first, and then when I seen that video, I like, oh, I got to go back to the courthouse and do a motion to compel, and that's what I did. And it's been like almost a month, and I haven't even got a response from them or a court date.
You haven't got a response for a court date?
No, from the debt collector, they haven't even responded after I did that motion.
Oh, how long ago was that?
Maybe probably about 3 weeks ago.
Oh, perfect. So give it like another week and we should be getting a response.
Okay. All right. Thanks for the information. Appreciate it.
Thank you.
Yep.
All right. Sateria.
Hello.
Hi, Sateria. How you doing?
I'm well. How about yourself?
I'm well.
Good. Thank you so much for this. We
No
spoke,
problem.
I think, middle of the week, this week or last week. Either way, let me jump into it. I have a summons and I'm requested to show, I think, January 28th for Navy Fed. I sent the response as advised. And should I get a response before that date,
You
just based
should,
on your experience?
but even if you don't, still show up.
Okay, still show up.
Don't even bank on a response. I wouldn't even bank
Okay.
on it. Do
Just
good.
plan
If
to show
not,
up.
our whole mindset is showing up.
Okay. And then all of these letters that we're writing, these motions, I'm sorry, should I send copies to the original creditor, the third party collector, and the courthouse, all certified?
So you send it to the courthouse and the attorney for whoever's suing you. You send
Okay.
it to both of them certified.
But not the original creditor.
If they have an attorney representing them, don't send it directly to them. Send it to whoever the attorney is.
Okay. And something I noticed about this account, I was looking through my paperwork. This is the second time this account has been sold. There was a previous LPA company,
Wow.
and now it's a second company.
So what I would do, well, we've already drafted our response,
Right.
but you can also outside of court request a chain of title or chain of assignment to see who all has owned it and see if it's even a proper chain
Request a chain of title.
or chain of
To-
assignment. Two different,
Hmm.
same thing, but it goes by two different names.
Okay. And who do I request that through? The court?
Oh no, whoever currently owns it, you can request it.
Current owner. Okay. I think that covers it. No arbitration agreement with Navy Fed. Oh, remember, I watched your first video and you mentioned there should be an assignee or a lead plaintiff on the summons or the, I don't see those terms, assignee or lead plaintiff. However, I do know this is the second time at least that it's been sold.
Well, something even better to put, can I say it, Cecilia? Would you rather me say
Of
it? publicly?
course.
Oh, okay.
Absolutely not.
Something even better on your paperwork, I don't know if you noticed, is we'll flip to the last page and read the bottom.
Last page.
Yep.
Okay.
Just to prove to you, I be reading all the stuff you send me. And that was a long document too.
Yeah. So let's see, the actual agreement that they have attached,
Oh, not the agreement, like read through all.
just the actual
Yeah,
summons.
at the bottom.
Okay. To the best of my knowledge and belief, the defendant is or are not on active duty in the armed forces for the United States, nor any branch thereof. Defendant is or are not an infant or incompetent person. In witness whereof I have unto subscribe my name and affix my official seal the 15th day of July 2024. Is that the one?
This says something about they're a debt collector and this is an attempt to collect the debt.
Oh, that was the affidavit. Okay, hold on. Those are the questions. Certificate of Service of Discovery. I don't know if I'm, because you know how they attach certain documents to the end of it. I'm just, okay.
Let me see if I can pull it back up.
Judgment. As a result, there is no genuine issue to any material fact as defendant has admitted all the elements of plaintiff cause of action and plaintiff is therefore entitled to judgment as a matter of law. Oh, this is a communication from a
Yep,
debt
big one.
collector in an attempt to collect a debt. Any information obtained will be used for that purpose.
So now y'all remember what I called, this is like 3 or 4 years ago when I called Navy Federal, American Express, all them debt collectors, and 80% of the internet, including attorneys, attacked me, said it wasn't true. On her lawsuit paperwork, read it one more time, Sarah. What did Navy Federal refer to themselves as?
This is a communication from a debt collector in an attempt to collect a debt. Any information obtained will be used for that purpose.
Directly from Navy Federal. Now I'm going to explain why they have to say that. Because again, in the FDCPA, it says when it defines a debt collector as somebody who collects on behalf of another. So because they're securitizing these debts, they're no longer attempting to collect for themselves. They're attempting to collect for whoever they securitize those debts with. So now they have to actually refer to themselves the same way LB&B funding refers to themselves. So the reason why I told Satiri this is a beautiful thing was because if you look at like, all right, so they refer to themselves as that, so that means that they subjected themselves to the FDCPA. So now they have to define the word account or agreement under the FDCPA. Has anybody ever seen that definition under the FDCPA?
No.
Doesn't exist. And that's how we beat them.
So now, and I don't know if this is too much to go into. You said prepare to go to court in January.
Yeah.
So when I show up to court, what am I showing up with? And
This
do
first hearing is not going to be trial, so don't expect that. They're just going to ask you if you agree or disagree. Just tell me you disagree, and then don't talk to the attorney. He's going to tell you, he's going to try to get you to settle right then and there. Tell him you're not interested. And you don't have to talk to him. You just keep moving. All the judge is going to ask for this first hearing. If this is the first one, is do you agree or disagree? You just tell me disagree.
Okay. Okay. Anything else you need? Any other input
That's it
for
for now.
that?
Just
Okay.
show up, and then once it's done, hit me up again, and we'll put our game plan together.
Okay, sounds good.
right.
I appreciate you.
Oh, my pleasure. All right, Darius Butler.
Oh, I'm sorry. I think I forgot to take my hand down. Sorry about that.
Oh, no
You
problem.
answered my first question, though.
Okay, cool,
Thank
cool. All right, Randy P.
Hey, how's it going, bro?
Well, how about yourself?
I'm doing pretty good. Had a quick question for you. I'm being threatened to be sued by Mahalia. They're a student loan servicer. They took over for Navient. They were recently in the news because the government used them as a contract, and I guess they weren't honoring their contract, something like that. But just wanted to see if you had any insights as far as dealing with student loans.
Hold on, bro. Let me look Mahalia up real quick.
I can put
I've
the
heard that-
article in the chat.
I've seen him a few times. Let me see. So first thing well, they haven't sued you yet?
No,
Okay,
no.
so, you could send them a letter saying that you're aware that, they use a process securitization tool, but there's not much you can do before, so they're threatening, that don't mean they're gonna sue you, bro, but if they do, the first thing that you wanna look for, if they do, is cause I was just reading about them. Does your lawsuit possess your name and account number? Most student loan furnishers never have that because they transfer this thing so many times that so much information gets lost in translation. So that's the first thing I will look for. Then from there, I draft my response based on that.
Okay, so I gotta wait for the suit.
If they even do it, it may just be a threat. A lot of times they are empty threats.
All right, so the tough part is like when I signed my student loan, I had to get my grandparents to sign for it too, or to co-sign. So they haven't been able to contact me, but they keep contacting my grandparents. So I'm just trying to figure out like should
You
I
want them to stop calling your grandparents?
I do. Yep.
Go through the CFPB and send them a cease and desist.
CFPD. Okay.
Consumer Financial Protection Bureau. And just tell them to cease and desist all communications.
Okay, and that's even if they signed on it as a co-sign.
Yep. You have the right to tell them stop communicating with you or your grandparents.
Awesome. I appreciate it, bro.
Oh, my pleasure. What would you do if a debt collector already satisfied a judgment, but they never proved they had ownership? Debt collector already said, oh, I'd go back to federal court and sue them with proof of all of that. The main thing, y'all, when you handle situations is getting on offense because we spend too much time on defense. So, when you're on defense, you could possibly stop the other team from scoring, but when you're on offense, you have a chance at scoring. So you don't want to spend too much time on defense. Get on offense. That's the name of the game for me. I like to get on offense. All right. So we're going to end there, y'all. This recording will be up on Monday. I appreciate all of you. Thank you all for tuning in, dropping I love myself in the chat if you enjoyed tonight's class. Peace and love to you all. I love you all and I love myself. All right. So that's improper service, Anna. Improper service. You can actually get that dismissed just based on that improper service. One thing to keep in mind is that the consumer has the power. The laws are written in your advantage. Yes. Thank you, Suhail. Thank you. All right. I appreciate y'all. Peace.